Good morning, friends. I'm happy to be able to share some of my thoughts to this August audience of technology specialists. But today I am going to discuss how the position of a data protection officer is changing the scenario in the professional setup to which all of us are today accustomed to. We have called this presentation as DPO, the new destination for CISOs. It automatically implies that today's CISOs who are already in the top management cadre in an organization could look up to the position of the DPO. Of course, after some time, we will start having a separate designation as CDPO, but as of today, we will discuss the role of DPO as if there will be only one single DPO for an organization. But as we go forward, I anticipate that large organizations will need to have multiple DPOs and to coordinate their activities have a chief DPO also. This multiple DPOs may be segregated in terms of roles based on their location and applicable law or in any other manner which is suitable for the organization. So it will be an interesting corporate development which we will be seeing in the coming days, where this new person called DPO will emerge as a person who cannot be considered as somebody who is um, perhaps below the current hierarchical level to which CISOs are accustomed to, or a CTO in some organization. In some organizations, the CCPO may look all powerful, but as we go forward, the DPO will challenge most of these chief officers, perhaps to the exception of the CEO. But we do not know. We are even expecting a DPO to be a position which will report directly to the board in certain cases, in which case we will have the DPO position challenging even the CEO. So this is the scenario in which we wanted to see DPO as a role which could be a new destination for the CISOs. This is the theme of this particular discussion. Now, I would like to look at this in three different parts. First of all, we will try to understand how this role of DPO is emerging in an organization. Then we will get into what I have called as Bradman versus Sobers debate. Of course, this is more easily understandable by people who know cricket. But basically, we are trying to debate the role of a CISO versus the role of a DPO. And then if one has to look at the role of DPO as a destination, then we will try to understand what are the requisites of a good DPO. And in that context, we will try to understand the data protection law. Of course, whenever we speak of data protection law today, the first thing which comes to our mind is GDPR. But today, I would like to discuss more about the Indian data protection regulation as it is emerging, because we are trying to prepare ourselves for the future. GDPR has been there since May 2018. To some extent, we are reasonably aware of its implications, but what is coming up maybe in a couple of months is an Indian version of a data protection regulation, and we need to understand what is this new act which is coming up in India, which may be called a Personal Data Protection Act, and how does it relate to GDPR, and how does it disrupt the role of a professional in an organization? To understand this, we need to go deep into what is the Indian data protection law as it is applicable today and as it will be applicable in a couple of months ahead. Now, if you look at GDPR and look at the timeline of the development of data protection obligations of an organization in EU, we know that this 25th May 2018 was a date which segregated two eras. One is the pre-GDPR era and the other is the post-GDPR era. Europe has a history of legislation supporting the privacy, and we were all aware of OECD principles followed by the EU directives, and the regulations or the laws passed by some of the major countries like the Data Protection Act of UK in 2008 or something like that. But what happened on 25th May 2018 is that the Europe actually introduced a general data protection regulation which was applicable to all the countries coming under EU, and without the need for a separate legislation in each of these countries, this GDPR became commonly applicable to all the countries. In between, of course, UK exited EU, therefore they came up with a new law which is called the new, let us say, UK Data Protection Act of 2018, and in that UK actually imported all the provisions of GDPR as part of the UK Data Protection Act of 2018. Therefore, they also in a way merged with the EU in terms of privacy protection regulation, though the EU may have its own reservations on extending all the privileges available to the EU to UK for some more time. That is, the question of adequacy and other things will come up maybe after a cooling period. But still, 25th May 2018 became a deciding milestone in the history of privacy protection, at least in the EU. The most important impact of this 25th May 2018 regulation was a fear of 4% penalty which was imposed on the organizations. In fact, privacy protection was understood before GDPR came, and we understand it in a particular way even after GDPR has come. But what has changed is that the GDPR regulations actually up the ante as far as non-compliance is concerned, and suggested that the penalty for non-compliance of GDPR could be as high as 4% of the global turnover of an organization. In fact, this is the single most important aspect for which the regulations of GDPR became a matter which the top management of any organization could not ignore, and therefore the privacy issue became the managerial priority. Before this, whether it was GDPR or maybe we will also have the same argument when we talk of PDPA, an organization had the CISOs, CTOs, CCOs or CROs as part of the CXO team. They were working closely with the CEO and driving the policies of organization. whether it was the new business which they had to take, new technologies they had to assimilate. All these things were taken as a decision of the CXOs, and many organizations were led by the CTOs because technology was the driver for many businesses, and therefore a CTO was the person who was calling shots in most of the cases. In certain cases, with the increased, I can say, recognition of cyber security risks, CISOs also gained a lot of importance. CCOs in many organizations were an extension of the legal responsibilities. Perhaps they did not get as much importance as was necessary. And of course, CROs was there for the whole business related risk. The so-called privacy officer as a designation was perhaps present in some of these organizations, but nobody recognized the privacy officer as a CXO kind of a person, and he often remained as a support person for any of the other CXOs. Now, post GDPR, this privacy officer assumed a larger than life importance because he was the person who was perhaps responsible for protecting the organization from this 4% penalty. So this person also got a new statutory designation called the data protection officer in many of the organizations. And though the word chief might not have been associated with this designation, he automatically became a member of the CXO club. And as I was mentioning, in many organizations, this DPO was reporting either directly to the CEO or to a board. And in fact, most of us who recommend a governance structure for data protection, we suggest a creation of a governance committee in which an independent director of the organization will also be there along with the CEO, and DPO will be reporting to that board rather than any single individual. There are, of course, many companies in which the CISO has also been designated as DPO. In some cases, CCPOs have been designated also as DPO. These are aberrations which will actually vanish over a period of time. And in fact, there have been instances in the EU where penalties have been imposed on companies for having combined the role of a CCPO and the DPO because the supervisory authority found that there was a conflict of interest. And the conflict of interest between CISO and DPO is more well recognized, and same way with the CTO or the business in charge. So conflict, if it can be recognized even with the CCO, then obviously the DPO designation cannot be combined with any of the existing CXO designations. He has to stand alone. That is why in the post GDPR scenario, the data protection officer assumes a very important role in an organization, and perhaps he will be at least on par with the CISOs and others, and maybe even a step higher, because the role of a DPO is defined in law, and it is defined in such a manner that he will be a watchdog over the organization, which means that even the CEO has to be circumspect about what observations the DPO will draw about the activities of the organization, because the DPO has a role directly reporting in certain circumstances to the supervisory authorities. So therefore, the role of a privacy officer, which became a data protection officer, has brought in a great disruption into the hierarchical setup of the organizations, and definitely this is going to be affecting a lot of CISOs. I believe that I am addressing a large number of people here who are actually holding the designation of the CISOs. And I am making this particular remark that CISOs have to watch out and look at how the coming up of this data protection regulation in India would change their the CISO's status in most of the organization. This change of role is something which we need to actually observe. In India, of course, we are today talking about a bill called Personal Data Protection Bill 2019. Otherwise, we have today Information Technology Act 2000, and that is the data protection law as of today. Sometime during this year, we expect the Personal Data Protection Bill PDPB to become a law, which may be called PDPA 2021, and we will have a similar situation which the EU companies had of pre-GDPR and post-GDPR. We will be having a situation of pre-PDPA and post-PDPA. But as of today, if somebody is thinking that PDPA is only a bill and I don't have to look at that, I beg to differ from that thought process, because the way India actually is introducing this PDPA is very unique in the sense that we have a law today called Information Technology Act 2000. It was amended in 2008, at which point of time a section called Section 43 capital A was introduced that related to the responsibilities of an organization for protecting the sensitive personal data. And whatever rules were introduced under Section 43A, which actually came up in April 2011, was a replica of the privacy protection requirements which we today are seeing in a GDPR or any other similar regulation, which means that Section 43A rules had most of the requirements which are today considered as part of the GDPR, like adopting certain basic principles like purpose-oriented collection and minimization of data collection, and using it only for the particular purpose, deleting it after the purpose is over, that is retention restrictions, and any other thing like rights available to the data subject, like right to access, right to correction. All these things are part of Section 43A rules, including the cross-border transfer restrictions. So what we have today in terms of 43A is a simplified version of the what will be coming in future as the PDPA. The only difference is PDPA will bring in a regulatory authority called Data Protection Authority, whereas Section 43A was only regulated by the system of adjudication, and normally ITA 2000 always was considered as a cyber crime law, and therefore the provisions of ITA 2000 could be invoked only when some victim comes up and says, I have suffered a certain damage. So the cause of action should have preceded invoking some provisions of Information Technology Act, and then only the adjudicator will come into reckoning. Though the law provided that the adjudicator of Information Technology Act had suo motu powers to actually come in and take the role of what we think DPA should take today. No adjudicator actually took that additional responsibility, because we actually designated the current IT secretaries in different states as the adjudicator for the state, and the IT secretaries had their own other responsibilities. They were not dedicated to the regulation of Information Technology Act related issues, and even when some complaints were taken to them, they were not that keen or enthusiastic to take over the role of a chief judicial officer of the state, which was what adjudication system actually made them to be. Therefore, the current situation, all the legal provisions of PDPA are available in the form of rules, but the implementation mechanism is either not there, or you can say it is weak, not recognized. But what will happen after the notification of this regulation is that we will be having a regulator, and that regulator, which will be a body with about 7 persons, with a chairperson and 6 other members, who are all experts in different areas of say the industry. They will be actually watching the technologies environment in the in India, the legal environment across the world, and maybe conducting independent audits of companies whenever they need to check how things are going in a particular company, besides responding to specific complaints which may come from time to time. So there is a proactive role which the Data Protection Authority in India will exercise, and that will be the biggest difference between the pre-PDPA scenario and the post-PDPA scenario. As far as the fear factor is concerned, the 4% penalty system applies even in PDPA. Therefore, just as in the case of GDPR, the managements will have to be conscious of the fact that non-compliance of the provisions of PDPA could lead to a very huge penalty for their company, which may often be debilitating for the company, and some of the companies may never recover from a major penalty like that. So that is what we are now driving at, and we in India are today expecting that anytime this kind of situation may arise. Most of us who are in the data privacy scenario, we are aware that if the law comes on a particular day, it is not possible for an organization to be compliant with the law from the very next day. Of course, we expect that just as GDPR gave 2 years time from 2016 to 18 for actual implementation, Indian lawmakers also may give a time of at least 1 year for organizations to actually get into the compliance mode. Sometimes they may give a shorter time for compliance and a longer time for applying for penalties, as some of the other countries have done. Something like they may give 1 year time for being in compliance, and maybe they will voluntarily say that for another 6 months or so, no penalties will be imposed by the DPA. So we may get some time. However, building a privacy culture compliant to a complex law is not something which an organization can achieve overnight. In fact, Information Technology Act came in the year 2000, but even today, most organizations are not compliant with ITA 2000, and some of the people think they are in compliance with ITA 2000 without understanding where the gaps still exist. Because there is no specific regulator and the adjudicators don't want to take suo motu responsibilities, and the law can be invoked only when a victim is able to come up with a particular say claim either before the police or with the adjudicator. Companies are little complacent today as far as the compliance to Information Technology Act is concerned. But that complacence will not be allowed in the PDPA scenario, because PDPA is a legislation which will not wait for a data breach to happen before the authority may come up with a claim for penalty. So it's a proactive law. It encourages organizations to be compliant to prevent the occurrence of a crime, and therefore penalties may become applicable even if there is no data breach in an organization. In fact, we have seen in the GDPR scenario that not appointing a DPO itself has been considered as a major non-compliance issue. And though there is no data breach in the organization, there is no victim of any uh, privacy breach, companies have been asked to pay damages. Similarly, in India also, because there are provisions such as registration, some organizations need to register themselves with the Data Protection Authority. If an organization does not recognize that it is falling into the category of registrable uh, entities and therefore doesn't go for registration, that itself can be a point on which penalties can be applied. So therefore, we are having a situation arising where organizations cannot be as complacent as they were in the current scenario. Though Section 43A talks of sensitive personal information, which is applicable to one subset of the personal information, which consists of a password, financial information, health information, and so on, there is a category of non-sensitive personal information which is also covered under Information Technology Act under Section 72 capital A and under Section 43 also. So non-compliance of the provisions of Section 43 or Section 72A or some associated sections like 67C or 69, 69A or B, all these things are part of the current data protection regulations in India. Therefore, as of today, we cannot say that there is no data protection law in India. Now, what is happening in the introduction of PDPA is the government has cleverly said that the moment PDPA is notified, it will replace the Section 43A of ITA 2000. In other words, 43A of ITA 2000 will be dropped and PDPA will come into operation. This establishes a legislative relationship between the current Information Technology Act and the forthcoming PDPA, which is currently in the form of PDPB. Therefore, there is a seamless change from the regulatory provisions as applicable in ITA 2000 to what is coming up in the PDPA. Along with this, the current ITA 2000 under Section 43A makes a reference to a concept called due diligence. That is, the reasonable security practices which are expected to be adhered to by an organization is also required to comply with the expectation of due diligence. What do we mean by due diligence is that if there is a general expectation that an organization should protect data in a particular way, that expectation is what becomes the due diligence. That is, if the whole industry thinks that personal data should be collected only on the basis of an informed consent, then even if Information Technology Act doesn't specifically say something, it becomes a due diligence to be followed under reasonable security practices. Therefore, the entire PDPB 2019 provisions today is considered as the expectation of the data processing industries in India, and therefore they are part of the due diligence expectations of an existing company coming under Information Technology Act. Therefore, all organizations who come under the provisions of Information Technology Act will be required to look at PDPB 2019 and adopt it as a part of the due diligence under Section 43A of Information Technology Act, read along with section 79, which is applicable to the category of companies which fall under the tagline of say the intermediaries. It is for this reason that we are saying that the changeover from the ITA 2000 plus PDPB 2019 scenario to PDPA India scenario will be very smooth and almost a sort of a seamless integration. And that is the reason why we feel that organizations in India need to start working at PDPB 2019 as a due diligence under the existing laws of Information Technology Act, Section 43A. This is the transition which we are urging companies to do. So the senior people in the organization like the CISOs, CTOs and the CEOs need to recognize that there is no possibility of us waiting for a day when the government will come and then only saying we say that we will be introducing new provisions of data protection. We should have started it yesterday, and at least we should start it today. So with this kind of a scenario, the role of the DPO is becoming so important in an organization in India, even as of today, that CEOs are now confronted with a new management problem, which is if a DPO is to be designated, how should I go about it? Should I pick one of my existing CISOs, CTOs or CCOs and then designate him as a DPO? If so, can it be a combined designation, or having designated a current CISO as DPO, I have to find somebody else to be called CISO? So that kind of disruption, how will it affect the rest of the people? And if I take a DPO from outside, how will he merge into the current top management structure, because it's a parallel position directly coming at the CEO level? This is what the CEOs will be confronting. GDPR provides that an external consultancy organization can be appointed as a DPO. In India, in the current PDPB bill, it is not clear whether external consultants would be permissible. So we are today interpreting that there will be a need for an employee of the organization only to be designated as a DPO. You can perhaps use an external DPO service organization as a consultant, but it doesn't mean that that external consultant can be considered as the DPO of the organization, and there is no need for the internal employee to be designated. So in India, we may require a designation of an internal employee as a DPO, even if, because of the requirement of the kind of expertise which is required, you may still need the need of an external consultant. Maybe some of this will be clarified when the DPA, that is the Data Protection Authority, comes into being and gives its own clarification. But otherwise, we are talking of one of the existing employees of the organization or a newly recruited employee of the organization to be designated as a DPO, and he will start sitting in the CXO meetings, and sometimes he will be objecting to the business propositions or the technology propositions from the context of non-compliance of DPO, data protection law, and that is where confrontations can arise within the organization, and CEOs need to ensure that the current, you can say, the balance which they have created amongst the executives doesn't get disturbed. And in fact, I, as a person involved in a lot of corporate issues, think that bringing harmony between the top executives in the context of data protection is itself a challenge to the management, and we consider that as one of the policy requirements which have to be implemented by an organization under our framework called Personal Data Protection Standard of India, or PDPSI, which is the recommended framework for data protection implementation in India. So this is the CEO's challenge, and organizations need to identify a compatible role definition for the DPO. For this, we need to understand the role of the DPO, and for understanding the role of the DPO, we need to understand the perspective of what we call as PDP CMS. What we mean by PDP CMS is Personal Data Protection Compliance Management System. We are all aware that there is a term called ISMS, which we use in the ISO 27001 context. And then we do audits and other things and say company is managing a good ISMS system. Then more recently, we came across a terminology called PIMS, Personal Information Management System, which extended the principle of ISMS into incorporating the privacy related issues which were there in GDPR, and we said that there is a separate audit 27701 for PIMS system. Now we are talking of a different nomenclature, PDP CMS, which is not same as ISMS. It may not be same as PIMS also. So we thought that it will be better to look at this as the PDP CMS. While ISMS looks at preserving the confidentiality, integrity, and availability of the entire data set with an organization, which is inclusive of personal data and non-personal data, PIMS extends this in a way to protecting personal data only, whereas ISMS protects the personal and non-personal data. PIMS brings a focus on personal data, where CIA has to be preserved, but along with that, it adds a few other requirements, which is the privacy of the data subject whose personal data is being processed by the organization. So ISMS focuses on the data. That is why the terminology data privacy became very prevalent. PIMS actually shifts the focus from the inanimate data to the person behind the personal data, which is the data subject. I don't know whether everybody has recognized this or not, but at least we in India have been talking about it for a long time, even in the context of Information Technology Act. And I have always been telling that we need to secure data to protect not simply the data, but the person behind the data. So PIMS, actually, the Personal Information Management System, looks at the privacy rights of a data subject and how to protect that privacy rights by protecting the personal data under the known concepts of confidentiality, integrity, and availability. Now, when we talk of PDP CMS, we are trying to be a little more realistic. Why do I say realistic? See, when we say we want to protect the privacy of the data subject, which is essentially the requirement of any data protection law, including GDPR, including PDPA, what we can do in an organization is not really protecting the privacy right of a person, but only try to protect the personal data as per applicable personal data regulation. That is, we are focusing on compliance, and we want the law to define how the compliance has to be managed, and we are trying to focus on that, because the concept of privacy is something which very few people would be able to define. In fact, the Supreme Court of India, which sat with 9 honorable judges in the case of Puttaswamy, what we call as Puttaswamy judgment, declared that privacy is a fundamental right in India. But they did not go and define what is privacy. They said privacy is a fundamental right, but they struggled to define what is privacy. They gave a lot of indications of their individual views in their judgments, and finally we arrived at a concept that privacy is a state of mind of an individual, and that state of mind is a feeling he has that he is free from interference. Now, when we are talking of interference in physical environment is tangible. We can see if I am doing something and if somebody walks in and stands before me, that is physically visible, and we can talk about physical privacy. But if somebody is disturbing me in the mind, then I am not feeling free. But at the same time, I cannot show to somebody else why I am not free and why I am disturbed. So therefore, when a privacy law is made, the lawmakers are not capable of creating a law that can protect the state of mind of the citizens. So what the law can do is to say that we will not be able to protect the real privacy, but we will try to protect what is called information privacy. That is what the Puttaswamy judgment also said. And what we mean by information privacy is that we will try to protect the right of an individual to choose how his personal data should be shared with another person, how it should be used, how it should be disclosed. So the right of choice of the collection and use of personal information became the main objective of a law like Personal Data Protection Act. So whether it is GDPR or CCPA or say Singapore PDPA, nobody can protect the privacy of an individual in the real sense the privacy activists understand. What all of us can try to do is to tell the data subject that I will try to make you comfortable that if you give me your personal data and tell me how it has to be managed, I will try to manage it in the manner in which you want it to be managed. Like I will collect only the data which you give me consent to. I will use it only for the purpose for which you authorize me. I will delete it as soon as the purpose is over. And during the time I am processing, if you want to know how I am using this data, I will give you that right of access. So like that, I can give you certain rights and adopt certain voluntary principles of processing, which makes you comfortable that your personal information which you have handed over to me is managed in a particular manner. This is the essence of personal data protection law, and that is why what we do in an organization in terms of data protection is nothing but looking at what is the regulation for personal data protection, and to comply with that we have a management system. Therefore PDP CMS, which is the personal data protection compliance management system, is what we as organizations are looking at, and we are looking at the DPO to be in control of this PDP CMS. And this PDP CMS is what we are in India trying to develop as a methodology for complying with the personal data protection law. Now, the perspective of this PDP CMS is, one, it is a techno-legal perspective, which means there are legal compulsions built into this management system. along with the technological innovations, and there has to be a balance. So there may be instances where I have got a great technical idea, but that great technical idea may not be allowed in law. Therefore, that is where the DPO will become a stumbling block to the CTO or anybody else in the organization. A business manager or even the CEO comes up with a business proposition saying that this is the greatest innovation which we are trying to do, nobody else in the world has done, but the DPO will raise a question, how does this affect the data protection regulation? How do we take care of it? The DPO's role is to raise that relevant question, and of course, the organization has to find a solution for that. The solution may be found again in the law itself. The law is not oblivious to the needs of business to do certain things with the personal data. We always say that data is oil, it is having so much of potential and so on. Lawmakers, at least in India, have not lost sight of it. The EU GDPR makers were a little more leftist kind of a thing. They wanted privacy, 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 nothing more. And for them, technology was an impediment. Whereas Indian law is not like that. Indian law tries to balance the needs of the privacy activists, the needs of technology or businesses, and also the need of the government, which has to use data for national security. So this three-way balance is what you find in Indian law. I'm not sure whether the same level of balance is found in GDPR. GDPR is a little more oriented towards the privacy activists. CCPA is leaning more on the business, but Indian law is trying to find a balancing point. Not that we will always be able to find the exact center of gravity of these three forces pulling in opposite directions, but at least an attempt has been made in the framing of the law, and hopefully if the DPA also keeps this in mind, I think it will be a win-win situation for privacy activists as well as the business. So this DPO also has to adopt such a centrist approach, not being swayed entirely by the technology innovation requirements which are there on the one side and the legal compulsions on the other side, and find a midpoint. That is why a person who is a hardcore legal person, he may have to shed some of his legal, you can say the dogmas, and give in to the technical people. At the same time, a technology person, if he is into a DPO role, he has to give up some of his dogmas that I can do anything with technology and try to put a self-control, which is a legal compulsion. That is why we say there is a need for a centrist approach with equal acceptability for law and technology. This has to be built into the PDP CMS system, and it has to be the guiding force for the data protection officer. It is here that to understand this conflict between the CISO and the DPO, because sooner or later we will be debating who is bigger. Now a DPO is there. Now when it comes to the organizational hierarchy, who is bigger? CISO is bigger or the DPO is bigger? CISO is so far reporting only to CEO. Now in some organizations, DPOs have started reporting to the board. So obviously this confusion will be there, and we need to resolve this. And to understand this, I am trying to draw some thoughts from my favorite game, which is cricket, which I have called as the Broadman versus Sobers debate. That is, who is greater, Broadman or Sobers? Okay, now this kind of a thing also comes here in the data management scenario. See, an organization has got data, which universe consists of personal data, and whatever is not personal data is non-personal data. Say we are taking this approach of defining non-personal data as a residual of what is personal data, because there is a law which defines what is personal data. There is no specific law for non-personal data. A law like Information Technology Act defines data as a binary representation. Okay, so anything which can be represented as a binary and together it makes some kind of a sense is data. And out of that data, every data protection law, whether it is GDPR or Indian PDPA, defines what is personal data. Then when you pick out that personal data, what is remaining is non-personal data. Now, the CISOs at present are having the responsibility for protecting this non-personal data in terms of confidentiality, integrity, and availability, and they manage it through technology. There are, of course, some advanced interpretations of the CISO's responsibilities where you build in a kind of authentication and non-reputability, and then say CISO will take care of the assurance. The assurance which he brings in is that a certain set of data is reliable to be used by the management for decision making. So CISO is today protecting non-personal data basically under the CIA concept using technology. Now, when it comes to personal data, the DPO comes in and he is actually dealing with the set of personal data which is smaller than the set of total data. But apart from looking at confidentiality, integrity, and availability of personal data, which is, you can say, part of the CISO's responsibilities, he has to also look at what are the rights of the data subject. Am I trying to protect those rights? What are the obligations cast on me by the law? Am I doing things accordingly? And what are the accountability aspects which the law expects me to do? Am I holding myself to that accountability? So, though the number of data sets being managed by the DPO is less than the number of data sets managed by the CISO, the complexity of his responsibilities are wider. It includes law, it includes technology, it includes public relations. Why do I say public relations? Because protecting the rights of data subjects, in India we call them as data principles. Now, protecting these data principles is something which requires dealing with the individuals who actually come up with all sorts of complaints about an organization. Sometimes you suddenly receive an email saying that I want to know whether my personal data is being processed by your company. Please let me know. And if you are processing, give me the details. And if you are processing, I want you to stop it from tomorrow and then give me confirmation that you have stopped processing my data tomorrow. Say it is easy for a data subject, any one of the 130 crore people in India, to send you an email asking for what we call as right to access and information about how the data is being processed. But if I receive such an email in an organization, to find out who is the person who is asking this information, do I have his information? And if I have the information, do I know what all I am doing with the information? Do I have the capability of segregating his information and deleting it or something like that? Is a huge task. That is why the DPO's role is more complex than that of CISO. If you look at an inventory manager in a manufacturing industry, let us say somebody is managing the inventory of the organization, a steel company or whatever is that. Now, amongst the inventory, let us say there are certain explosives which are used as part of it, the business, let us say. Now, having these explosives in the same store in which you are putting steel or something is will have its own legal complications. There is a separate law for say buying, storing of say explosives. So the inventory manager, who was hitherto managing all the steel products and other things very well, avoiding say rusting of material or something of that nature, now suddenly he is confronted with a new consignment which has come into his go down, which is marked there explosives handled with care. Now he has to now understand what is this explosive, what is the chemical property of that, and how does he protect it. Is it required for him to keep a temperature limitation, uh, or should it be kept separate from other inflammable goods, something like that. So a whole knowledge of the law related to those explosives becomes essential for that inventory manager who was hitherto not handling explosives. Now the company can decide that I will not have the same inventory manager to take care of both. I will have a special inventory manager for sensitive inventory, and then give him a separate go down if necessary, or within the current go down I will make a separate let us say enclosure, but I will expect the responsibility for managing this to be taken care of by this sensitive goods inventory manager. Now, obviously, the sensitive inventory manager will have his own points of difference with the inventory manager, because he would also like to have a key to the same godown, because he wants to enter the godown to his space whenever he wants, and he wants that no other inventory of a um, explosive nature or inflammable nature is brought near this. So he will start defining what the other inventory manager has to do. He will say, don't put this goods next to my good, kind of a thing. That is where the conflicts will arise, when somebody who is now designated to secure a sensitive part of the inventory walks into a current environment which is being managed by somebody else. The same situation comes in the data scenario, that the entry of DPO saying that I want to protect the personal data as per a particular law. And the CISO says, I am already protecting your personal data. Nobody told me, but I considered that as part of my data. So why are you thinking that I am not capable of protecting personal data? There, the DPO will say, dear Mr. CISO, you don't know what is Indian Data Protection Act, you don't know what is EU GDPR, you may know certain technology tools and other things better than me, but take it from me that as far as the data protection laws is concerned, this is how you should handle it, and presently what you are doing is not correct. That is where the DPO and CISO may come into a clash, and that is where we may have to decide now whether Bradman is bigger or Sobers is bigger. Of course, in most of the cases, we don't distinguish, both of them are good. But remember, if in a cricket match only batting was required, maybe Bradman is the best person. But that is only half of the game. The other half of the game is bowling, and maybe Sobers will be the better person. And that to a person who can bowl both spin as well as fast bowling, so that depending upon the situation and the wicket, he can change his capabilities and use his skills. That is what will be the Bradman versus Sobers debate brought into CISO versus DPO debate. Okay, uh, though we don't want to create a clash between the two designations, we should understand and appreciate that the roles of the CISO and the role of the DPO is different. We may need both, but between themselves, they should not start dictating that I am bigger than you. This challenge faced by the DPO is more complex, and it involves greater variety of skills, and that should be appreciated by the CISOs. This is where I go with the acceptance of the uh, theme of this particular discussion, that DPO may be the destination of the CISO. When we say that is the destination, we are saying that to be a DPO, it requires something more than being a CISO. So without using the word who is bigger, better kind of a thing, we can only say that a DPO requires more skills than the CISO. So in an organization, both have to work together, and where a technology tool is to be evaluated and used, CISO's expertise will come into being, and the personal data manager, who is the DPO, will perhaps be able to manage the situation better. It is the same argument which we have in the cricket field: who will be a better captain? Whether a batsman will be a better captain, bowler will be a better captain, or an all-rounder will be a better captain. I'm sure you will be able to decide on your uh, own. Similarly, in the role definition of a DPO or CISO, we may have to define that the current CISO, if he acquires additional skills, then he is the best person suited to be a DPO, but simultaneously, he may not be both the CISO and the DPO. Therefore, I look at a scenario that in the coming days, a number of CISOs may move out of one organization and join other organizations as DPOs, because that is more challenging and it is more interesting. See, after 5 years, 10 years as CISO, you may get bored with what you are doing, but in the DPO role, there is nothing to get bored. It is more challenging. You involve more people in your interactions, and I'm sure DPO role will be much more interesting than the CISO uh, role. So many of you would be happy to change over to this particular role. To understand this role of DPO, the first thing we should remember is that DPO is a custodian of personal data, and in terms of compliance, he is the custodian of the personal data protection compliance management system in the organization. He is the trustee of the faith of data subjects, because he has to see that the organization follows the principles of data protection. Organization protects the rights of the data subjects. DPO is the watchdog of the regulator, who expects the DPO to come up with a data protection impact assessment, DPIA references. He expects the regulator to actually, the DPO to come up and provide data breach incident notifications. Therefore, the DPO is the watchdog of the regulator. And when it comes to disputes between data subject, DPO is the negotiator. So the role of DPO involves a variety of responsibilities, and that is why I call it as a something which a true all-round leader possesses, and that is where he should be more a sobers than a broadman, and that will settle the issue of who is going to be the better DPO. Now with this, if we agree that the role of the DPO is more complex, at the same time it is more challenging, and there are a lot of us who want more challenging jobs, because we want to have a career of 30-40 years. We cannot keep doing the same thing for 30-40 years. So we need challenges. So a challenging role is always better than a less challenging role. So I consider that DPO is the role to aspire for the CISOs. And with this background, we can start looking at the legal aspects and try to understand what is privacy, what is data protection compliance as envisaged under a typical regulation like PDPA of India, which is our focus. So this is where we begin our next stage of discussions. Now, the evolution of personal data regulation in India, as I already pointed out, starts with the current law, which is Section 43A of ITA 2000, and with certain other things in Section 72A and 67C and some other sections. Then we are now in the PDPB 2019 scenario, which will become perhaps PDPA 2021 very shortly. But even after this law comes into being, the personal data regulation will continue to evolve because of the regulations and notifications which come from the DPA, including certain codes and practices which the Data Protection Authority will suggest. As an industry person, I don't know whether the DPA will be coming up with codes and practices which are not entirely acceptable to me. And at that time, I will be going and fighting with the DPA that something is not correct. So what people like us have started doing is we have created a shadow DPA kind of an organization, and we are coming up with our own personal data protection compliance codes and practices. And probably when DPA comes, well, when I say we are talking of the FDPPI, the Foundation of Data Protection Professionals in India, an NGO kind of an organization. We will be able to perhaps discuss with the Data Protection Authority. This is what is a good self-regulatory practice which a certain sector has adopted, and please ensure that most of these things are incorporated in your codes and practices. So that is what we are trying to do as a proactive measure, but the regulation as a whole will consist of not only the act which we are having a version. This version of the bill may undergo some changes. People are talking of a number of amendments which the Joint Parliamentary Committee has introduced. Of course, I had an occasion to have a discussion with the Joint Parliamentary Committee and put in our own suggestions. And to some extent, we know that the Joint Parliamentary Committee is going to endorse the general structure of PDPB 2019, while there can be always minor changes. And so what is going to come up as PDPA 2021 is unlikely to be much different from what is the character represented by PDPB 2019. But after that, it is a continuous exercise where the DPA will come up with notifications almost every alternate day, and the industry will have to ensure that they are in tune with these developments. So this is how the data will be. We can continue from where we had left off. Okay. We have so far discussed the relevance of data protection compliance management system to be developed by an organization. We have also discussed the role of the official who will be having this responsibility in an organization with a new designation called the DPO. And also we have highlighted the possible conflicts which this new designated entity will have compared to the existing hierarchy consisting of the CISOs, CTOs, and others. The idea of pointing out this difference is to highlight that the role of a DPO is much more complex than the role of a CISO, and therefore there is always a possibility of certain conflicts which are arising, and we as senior officials responsible for the overall good of the organization needs to understand why a DPO comes up with certain suggestions which appear bizarre and limiting the organization's capability to progress. Okay, we need to actually understand that and accommodate the DPO And particularly if the DPO comes from outside and he is not one of the current executives who is promoted into that role. Even if an existing person is promoted into the role, there will always be a dissonance, because number of people may think that all of us were eligible for this and only one could be promoted, so there will be conflicts. But the conflicts will be more when a person comes from outside. But as members of the top management of an organization, whatever designations I carry as a CTO or a CISO or a CCO or CRO, once a corporate decision is taken that some XYZ is made the DPO, we must understand that all of us have to work together as a team to ensure that the overall objectives of the organization to be compliant with the law is properly handled. Because if we don't do that, we have this Damocles sword of 4% penalty hanging our head. Of course, Indian law talks of a maximum of 15 crores for as penalty, but both GDPR and PDPA talks of this percentage of global turnover, or something like 15 crores in India or 20 million euros in GDPR, whichever is higher, it says, which means that we may have penalties running to more than 15 crores also. So therefore, we know that not all of us have put aside 20 crores, 100 crores or 200 crores as a money which can be distributed as penalty. Okay, even in the case of many banks, whenever there is a non-compliance, RBI goes for a penalty of 1 crore or 2 crore, not more than that. But here we are talking of 5 crores in certain cases, 15 crores in other cases, maybe more than 15 crores also. So therefore, this is what we as senior executives in an organization should remember, that whoever is the DPO, it is the responsibility of all of us to be to cooperative with that office of the DPO. Of course, as long as possible, we will try to occupy that position if that is good. But once that is over, uh, we should ensure that we work together. It is like the 12th man in a cricket match who goes out for fielding. He is one person who has not been accommodated in the playing 11. So, but he cannot keep that grievance and then go there and drop a catch, because if he drops a catch, it is the team which is going to suffer. Similarly, here, the uh, existing CISOs and CTOs and others have a big personal kind of a role to play in ensuring that the DPO designated person feels comfortable and we all cooperate with him. Now with this, if we go into understanding what is this law which makes this DPO so powerful in an organization, we will look at this Personal Data Protection Bill 2019. It presently has about 98 sections divided into 14 chapters, almost similar to GDPR, which has about 99 articles or something like that. Now, basically, this act, I'm not going into the detailed legalistic view of that, but I'm just giving a bird's eye view of that. There will be one chapter in which preliminary discussions are there on definitions and applicability of this law. There will be chapters on exemptions, that is where this law will not apply, because applicability and exemptions can be looked at together. There are aspects like what are the obligations in terms of compliance, which is what we call as transparency and accountability measures, which also includes the restrictions on transfer of personal data outside India for processing. So some of these things are contained in different chapters. Then there are a set of chapters where the obligations of the data fiduciary is discussed. There will be grounds of processing without consent. While the obligations of the data fiduciary may say that consent has to be obtained, there are certain exemptions on which consent may not be required. Then handling of minors data may be discussed under a separate chapter. Then the rights of data principal to be protected is a separate chapter. Additionally, there are other miscellaneous aspects like a chapter on data protection authority, chapter on the appellate tribunal who will work along with the adjudicator, and then a chapter on the finances, accounts, and other miscellaneous aspects, and of course a chapter on penalties. This is how the act actually segregates the different provisions. So as a compliance man, now I have to look at applicability, I have to look at exemptions, I have to look at the obligations, and then the accountability features. And for understanding the obligations, I should know where I have to identify the minors, because consent to be obtained may be, in the case of children, the consent has to be given by the parent, not by the person. So obligations and rights are two important things I have to build in to my accountability measures to be taken. So um, maybe in our CCO will be concentrating more on how to understand the adjudication and appellate tribunal, how to handle them. So like that, different parts of the act are important for different functionalities. We will try to discuss more about the compliance related issues which a person has to look into. Now, if we look at the impact of this PDPA, just at a glance, first thing we have to remember is that this is a legal mandate, non-compliance of which could lead to huge fines. That is, unlike a best practice in business, which is not a legal mandate, it is a best practice. I have to convince my customer that I am doing great in terms of maintaining the quality of service, so I adopt certain best practices. Here we are talking of a legal mandate. I have no option. The government wants me to do in a particular manner, I have to do it, otherwise I should be ready for payment of penalty. The second impact is that this particular provision of PDPA compliance involves technical implementations of processes and monitoring, which means that technology is still a good part of this PDP CMS, particularly if the organization is a technology company. The PDP CMS extends to the entire life cycle of personal data. See, understanding the life cycle of personal data itself is a very interesting thing. In fact, I have got something called the theory of data to explain the life cycle of personal data, which maybe briefly we will see in one of the next slides. But if we want to implement a compliance management system, we have to understand how personal data takes birth in my organization, how it changes from a chaotic data to personal data to sensitive personal data to de-identified data or anonymized data and to deleted data. So this entire change of the character of the binaries expresses the way data changes through its life cycle from birth to death. Okay, and compliance extends to this entire life cycle. Technology is involved in various aspects in this, and therefore this compliance system has to take into account the processes applicable to different parts of the life cycle of the personal data. The other impact which we as professionals are very much concerned is how it generates new employment opportunity and rearrangement of the corporate order. Okay, and if we don't handle this properly, we will lose our current position. It is like we say in competition, we have to keep running even to stay where we are. So similarly, now that this act is going to come, the day it comes, we are anticipating that a new person will suddenly appear next to me and call himself a DPO, and if I don't start running from today, then I may lose out the race to him in my corporate hierarchy. Therefore, while it generates new employment opportunities in one way, it also will have rearrangement of the corporate order, and those who are dynamic and forward looking will be able to get ahead of others, otherwise they will be getting into the background. Now, we will address some of the individual aspects of the law to understand the impact better. The first thing we have to always remember is any of these personal data protection laws, we have to start with understanding the applicability of the law. See, there is no point in applying GDPR to a data for which GDPR is not applicable. Same way, you need not apply say PDPA India to a data to which it is not applicable. So the first thing we have to look at is applicability. That too because as of today, it is said that more than 132 countries in the world have drafted personal data protection law. Either they have enacted it or it is in the draft stage, which like in India, and it is part of the due diligence. Now, these 130 countries have got 130 different laws. On the outset, they may appear similar. So, somebody may say that I am GDPR compliant, so I don't have to worry about XYZ law. But that is not a correct approach because each of these 130 laws are applicable in different contexts, and there may be certain small differences, but it is the small differences which make which create the challenge. For example, in GDPR, there may be no provision for registration of, let us say, an entity which we in India will be calling a significant data fiduciary. So it is, you are GDPR compliant, but Indian PDPA is notified, say today, then from tomorrow you will become non-compliant on one aspect, which is that you have not registered yourself as a significant data fiduciary, for which you may have to pay a penalty if the DPA wants to impose the penalty. Of course, he may send a notice and you may give a reply that I will do it, I was not aware of it, all that is there, okay, but conceptually you have been non-compliant because you thought you were compliant with GDPR and therefore you didn't have the necessity to look at the Indian law separately. But there is a very small difference that there is a registration required here, it was not required there. So applicability is therefore very important, and also Indian companies, many of us, we are a hub for data processing. So we would like to offer our services to clients all over the world. Some of those clients may be in EU, some of the people may be in Australia, some of them may be in Brazil, some of them may be sitting in the DIFC in Dubai. Now, will one law be applicable to all these people for the personal data processing? Obviously no, because GDPR is applicable for processing of personal data of EU citizens. Then Australian law may be applicable for Australian citizens' personal data. Then if you are from California, CCPA may be applicable. If it is from Brazil, LGPD may be applicable. Like that, there will be multiple laws which are applicable to multiple data sets. Now, if you have one application and you offer it on the web and say anybody can subscribe to my service here, okay, and I will do the back-end processing, okay, and then the clients from different say geographical regions start using your application and pump data, personal data from their region to your data center. Then each one will start asking you, are you GDPR compliant? Are you CCPA compliant? Are you LGPD compliant? Are you compliant with the Australian law? Are you compliant with the New Zealand law? Are you compliant with the Singapore law? So, which means that you, as a common data processor sitting in India, need to worry about the multiple laws because the applicability will be different. Now, data which is being generated from your client in EU, it has to be GDPR compliant. Now, you cannot apply the Indian data which you collect from, say, Bombay or any other place in India and start applying GDPR on that because the PDPA regulator will ask, are you compliant with my law? So therefore, the first thing is to understand the applicability. Now, applicability will have to be looked at from applicable to what data, whose data, and applicability on the basis of who processes it or where it is being processed. These are the four major uh, criteria which is used for defining applicability in Indian law and also in other laws. Now, what data to which this law is applicable? It is applicable to something called the personal data. Now, personal data means what? There will be a definition. Basically, personal data refers to any set of data which is identifiable to a living natural person. What then happens to a person who is deceased? Now, deceased person's personal data may or may not come under the same provisions as applicable to a personal data of a living person. See, GDPR is very explicit and it says it's not applicable to uh, deceased persons. But Singapore data says, protection law says, no, it will be applicable to deceased personal data for 10 years. HIPAA may say 50 years. So there may be other countries. In India, at present, specific clarity has not been given in the PDP bill, but we are interpreting that since the Indian law is meant to protect the fundamental right of an Indian citizen, it should naturally apply to only living persons. Okay, deceased person may have a separate right in the sense that rights which are exercisable by the legal heirs. The deceased person himself cannot exercise any right, but the legal heirs of the deceased person may have their own rights. They do inherit certain property rights, for example. In fact, recently there was a case in the Madras High Court where the legal heir of the deceased uh, Chief Minister Jayalalitha tried to establish that she has a right to inherit the personal data property of the deceased Jayalalitha. Court did not, as of now, has not agreed with that. We may see how the case develops when it goes into trial and other things. But it appears that if there are any rights of a deceased person, they may be in the nature of possible defamation or something like that. That's a different right, but it is not a personal data protection right as applicable to natural persons. So the data to which when law is applicable is to what we call as personal data. Now, what could be the identifiers? There are many times we distinguish between identity of a person and individual identifiers. For example, email is an identifier, but email itself is not the person. An email is one of the identifiers, and when it is combined with some name or some other parameter with which you can identify one living natural person, then it becomes a personal data. If you look at, say, Gmail, okay, today you may get hundreds or thousands or lakhs of Gmail IDs of people who have expired in the last few days or last month or a year, until Gmail removes them for being inactive for a long time, they remain. Okay, if a hacker or somebody generates a mail from that, you are getting the email in a particular name of a person, or you may send an information, or you may have the personal information of a person who is no longer alive. So it is possible that email ID may exist, but there may be nobody behind that email ID. So therefore, only when you link the two, it becomes personal data. There is also a debate on how to deal with business email IDs. What do we mean by business email IDs? If a person decides to use a particular email ID only for business purposes, then irrespective of what is the name which is used there, the characters of English or some other thing which is used before the word at the rate of, that is business email ID. It is not personal email ID. If I say vijay@gmail.com, that VIJAY need not necessarily be considered as a personal information. It may be just a representation of 5 characters of English alphabet, and that may be a business ID also. So there is no need to identify any data as personal data unless that data directly or indirectly is attributable to a living person. Normally, the attribution can come only when there are 2 or 3 parameters which are combined together. Even if I say Modi, you don't have to say that Modi means only the chief Prime Minister of India. Okay, there may be any number of Modis. So, if I have a personal data related to, say, Mr. Modi did so and so, it need not necessarily be considered as a personal data attributable to one particular person unless I add Mr. Modi, Prime Minister of India, then that becomes an identifiable personal data. So that is how we have to identify personal data, not go blindly by having an identity parameter like an IP address. IP address may be one of the parameters for identity, but that itself is not the identity. That kind of distinction is what we need to look at the time of applicability. Then whose data? It is applicable to the citizens, which means that the data of the natural individual, it is not applicable to the data of a company. Now you may say, why is that corporate data is not protected under PDPA? Because this is a special act for protecting personal data. It doesn't mean that you don't have to protect non-personal data. There will be a separate regulation for that. Today, ITA 2000 protects non-personal data. Tomorrow, there may be another law which may come to protect or govern, protect more than the protection. Governance also is required. So there may be a non-personal data governance act, and there may be a cyber security act. So Information Technology Act is already doing that. So the applicability of the data is for personal data of individual citizens of India. Now then, what happens to a non-citizen of India? Does PDPA extend to it? Now, this has to be looked at from the legalistic scenario as well as ethical scenario. Now, normally, every country tries to protect the values, democratic values. So if a foreigner is in India, let us say he's walking in the street and somebody is trying to assault him, definitely the police standing nearby has to protect him. He cannot say you are a foreigner, you are not like the person whom I am paid salary to protect or something like that. So there the question of our aggregated responsibility to society comes into being. So if a foreigner's data is involved in the processing, then probably we may have to say PDPA has to be applied to them. But Indian PDPA has recognized the possibility that an Indian company may be processing foreigners' data systematically, but there is some other regulator who is looking at it, like a GDPR or something like that, which happens in the case of BPOs in India. Say BPO in India is processing the data of a foreign country citizen, under a contract, and that contract establishes that the data exporter has taken responsibility for the protecting the privacy of the citizens of that country, EU. So it may not be necessary for the Indian law to protect the rights of foreign citizens if their personal data is being processed in India in such context where it is being alternatively protected. So Indian law has recognized this possibility and provided specifically a section 37 in which it says that an organization which is processing personal data of foreign citizens can get itself notified from the DPA and perhaps create a separate division in which this data of foreigners are being processed under a contractual arrangement, and PDPA authority will not interfere with that. He will keep it out. The same kind of recognition is not recognized perhaps in GDPR. So if a person establishes a data processing organization in EU region and processes the data of Indians, there may be no way of getting it exempted from the Indian from GDPR. So that is why if an Indian company is trying to use cloud services, and if the cloud provider is going to store the data in EU, and you are aware of that and you are also agreeable to that, then you will be voluntarily subjecting yourself to GDPR while it is actually not necessary. Okay, so there are various ways of avoiding the liabilities there. One is to make that cloud person a data processor and make him responsible for security, but rest of the things you do it. But if a GDPR authority asks you for how you are protecting the data under GDPR, we may say that we are not coming under GDPR, we are coming only under the Indian law. So that kind of distinctions we will have to recognize in terms of applicability. Now, as far as the organizations are concerned, see, PDPA or GDPR is applicable to protecting the data of natural persons. At the same time, that data is being processed by companies. So if somebody asks you a question, is GDPR applicable to companies? You may have to say that it is applicable to companies for the purpose of compliance. Otherwise, it is applicable to individuals as far as the subject to be protected is concerned. So if we leave that personal data element for the individuals and look at the companies, there are two ways companies are looked at. That is, companies established in India or in the same country, companies which are established outside that country. So when we apply a law like PDPA, any company which is established in India, wherever their data processing activity happens, they are primarily liable under the Act because they are companies established in India. That is where I said an exemption can be claimed if they are established in India and they become PDPA liable, but the data which they are processing is already subject to some other law. It is a unnecessary overlap of the regulations. There is an exemption prospect for which you have to make an application and get it done. Now, if data is being processed by an establishment outside the country, but the data relates to my citizens, or the company sitting outside is trying to profile my citizens, then every country will say my law should be applicable to that. Same way in Indian PDPA also, an Indian company is coming under the law if wherever it is established. At the same time, foreign companies will become liable if they are processing the Indian law. This is the general applicability clause which applies to every other law. That is why we say GDPR data is applicable. GDPR is applicable to GDPR data. Singapore law is applicable to Singapore data, unless you are able to segregate the incoming personal data based on the country of origin. You are mixing up everything and you will not be able to comply with the law as it is required to be done. You are unnecessarily complicating the process if you mix up the data. So you must have, as a technology measure, a proper classification system, classification based on the applicable law, and then segregate it into different data centers or logically created databases, and then apply the applicable law to that particular data set. That is the best way of managing the PDP CMS. GDPR and Indian PDPA, of course, more or less has similar provisions in terms of applicability. That is, in terms of one of the important things which you have to look at GDPR is it says that GDPR is not applicable if the personal data is being processed in the course of an activity which falls outside the law of the European Union. So if an European is actually in India and he is doing some activity here, and that activity, if it does not come under the provisions of the EU law, then there is no GDPR on that. That is where travelers are walking through, let us say, my mall or my shop, giving their personal data for some local purchases, uh, we consider it as applicable under Indian law. Because it comes under the Indian law, it does not come under the GDPR law. Okay. Now, that is there. In India, of course, we have stated it in a different way by saying that Indian PDPA is applicable only for data collected, disclosed, shared, or otherwise processed within the territory of India. Indian law specifically talks of that not being applicable to anonymized data. That is also applicable to GDPR, because what we mean by anonymized data is not de-identified data. Okay, anonymized data is data which is not identifiable at all as a personal data. So it is actually non-personal data. There are certain instances where data is born as non-personal data. There are certain instances where data is today personal data because an identity is associated with it, but I can remove the identity in such a manner that it becomes totally not recognizable to any individual, and that is called anonymized data. What we mean by de-identified data and pseudonymized data are such state of personal data where the identity parameters are either removed or substituted, but the removed identity parameters are kept in a separate table, and the substitution parameters are maintained in a separate table, so that whenever it is required, the de-identified data can be re-identified or pseudonymized data can be re-identified. If that is the technology used, that is called de-identified data or pseudonymized data, both of which are different forms of personal data only. But anonymized data is, first of all, removing the identity and then destroying that mapping information in such a manner that even the person who did the anonymization will not be able to re-identify. There are technology people who say that there is nothing called 100% anonymization. Therefore, there is a demand that anonymization should not be permitted, or it should be permitted only by a consent, and so on. I don't agree with that argument, because in terms of technology, nothing is 100% reliable, in the sense that, for example, you take encryption. If you look at HIPAA or High Tech Act, it says that if the data is related to encrypted personal, protected health information, then any loss of such encrypted PHI may not be considered as data breach. The idea is, because it is encrypted, the person who gets hold of the encrypted data is not having the real identity of the person, and therefore it is not a data breach. It doesn't call for some kind of penalty. But theoretically, we can argue that no encryption is perfect. Then, given the enough resources and time, you can decrypt anything which has been encrypted. Same way, people can argue that any anonymization technique you use, given as sufficient, I mean, application of technology and time, you can re-identify. But that is actually a cyber crime scenario. That is using extraordinary or unusual efforts to de-identify and anonymize data is a crime activity, and law can only say that crime is not permitted and we will punish it. But criminals are not going to listen to us. So therefore, any person who wants to use data analytics to re-identify and anonymize the data will actually be committing a cyber crime, and he has to be dealt with under the cyber crime laws. And therefore, once there is an anonymization under a reasonable anonymization algorithm, that should be considered as non-personal data. In fact, the Indian Data Protection Authority is likely to come up with a regulatory recommendation on the anonymization, what has to be standards of anonymization. Okay, so subject to that standards of anonymization, the data, if it is anonymized, then it becomes something outside PDPA. This kind of clarity is not available to that extent in GDPR, but we can presume that similar thing is there also. Then as far as the establishment being in EU or this, both say that if the data processing organization is established in my country, then it will be applicable irrespective of where the processing takes place. An Indian company putting a data center in, say, Timbuktu is still liable under the Indian law. There is no provision like we do in taxation. We don't have tax havens kind of a thing. Even if data is processed in a data heaven, still PDPA will be applicable, and vice versa in GDPR scenario also. So in either case, if an organization is sitting in one country and then processing the data of other citizens, then also the applicability will be there. So this is about applicability. Now, GDPR talks about the terminology called data subject and data controller, whereas PDPA India uses the terminology called data fiduciary and data principal. Data principal refers to something similar to data subject. Data fiduciary refers to something similar to data controller. This nomenclature itself has a big impact on interpreting the information, the act, because this data fiduciary usage introduces a duty to care, which means that though normally consent is obtained, permissions are obtained from the data principal for processing, and that consent is considered as a binding contract, beyond the words used in the consent, there is an expectation that data fiduciary will be having a certain duty to take care of the personal data. This concept of extra responsibility is what makes Indian PDPA more powerful from privacy angle than GDPR. Okay. Now, if you look at some of the exemptions, we have seen the applicability exemptions. One of the exemptions is, as provided in the Constitution, there is an empowerment to the government, which says that where it is necessary and expedient, the central government may direct for reasons to be recorded in writing, but only in the interest of sovereignty, integrity of the state, relations with foreign states, public order, or for preventing incitement to the commission of any cognizable offense related to the interest of sovereignty, integrity of state, public order, etc. In such cases, the central government is empowered to notify that certain agencies or certain provisions are exempt from not necessarily the entire PDPA, but on certain portions of it to the extent necessary. This particular exemption has been highly criticized even by people who are otherwise very knowledgeable because they don't like the government in some way or the other. This power of the government to get itself exempted is an enabling provision here, and it has to be exercised by writing and with some kind of justification. And this interest of sovereignty, integrity, etc., these are all the excuses which are available as reasonable exceptions under the Constitution of India under Article 19(2), and where the fundamental right of a citizen also can be overridden for such conditions. So the same provision has been made use of here, and the government has retained an empowerment to notify through a say gazette notification that XYZ organization can do that kind of processing of personal data. So this is not something which some people are saying that India is going to create an Orwellian state or something. It is absolutely not a realistic, way of understanding this provision. In fact, what we can appreciate in this particular section 35 of the current PDPB is that though the government had the ability to get exemptions on several more reasons which come under the Article 19(2), they did not use those provisions. For example, Article 19(2) not only allowed for reasonable exceptions in the case of the sovereignty, integrity of the state, public order, etc., but also on grounds of decency or morality, or in relation to contempt of court, defamation, or incitement to an offense in general. These things have not been taken into account while the government has retained its empowerment to get exempted from the provisions under a written order when necessary and expedient nature has to be proved. All those people, lawyers who are arguing about this are only harping on the meaning of the word necessary and expedient versus a word which they want as proportional or something like that. What we mean by necessary and expedient also means that it has to be proportional to the requirement, and that too it is only in the case of this international requirements and security of the state that this exemption can be obtained. Maybe some legal persons are unhappy that contempt of court is not provided as an exemption, but maybe there are other provisions under the act in which a judicial authority can seek some kind of an exemption. So that is not a big issue, but this is one ground on which not only a lot of criticisms have been placed on the Indian law, and people are already preparing to go to Supreme Court if the law is passed. But remember, similar things are already there in GDPR and any other international law, because we cannot have a situation where the law-making sovereign body will make itself completely incapable of imposing the law. As of today in India, the law enforcement is weak because we are not taking into account the national interest in most of the cases, and some of the um, uh, other interests which may be on smaller considerations override the national interest. That is why the farmers' agitations go on forever, and many other road rocos continue, where actually a government is expected to take much better decisions. So exemption provided under section 35 of the PDPB is well within the rights of the government, and let us leave that controversy aside. Other than that, there are exemptions for law enforcement, but these exemptions for law enforcement, judicial and legal defense is on aspects such as obtaining prior consent or certain rights. It does not apply to security. So all these people will have to maintain security, okay, irrespective of the um, particular exemption they make use of. Other than that, there is exemption from consent in certain circumstances, such as domestic purpose, for research, journalistic, and small entities doing manual processing. Then BPOs, as I told you, subject to notification. Plus, to support technology innovation, the PDPA provides exemption through sandbox provisions for a total period of 3 years. So if an organization needs to actually experiment with a certain technology, and if they feel that getting prior consent, etc., and exercising their rights, etc., is a hindrance, they can place their project under sandbox provisions as a project approved by the DPA, and thereby get some kind of an exemption. However, even here, the exemption does not extend to lacks of security. Security is still to be maintained, but maybe the prior permission, or arguing whether the permission was complete, because many times we take permission for a particular purpose and then you discover a new purpose, and normally the law says is that the consent taken for a specific purpose should be used only for that purpose, and if you want to use it for any other purpose which cannot be justified as incidental purpose, then you have to take a reconsent. Now such things can be avoided in sandbox provisions. Similarly, when data is placed in a public place, now there is an argument whether the public data can be used. Now, normally we say that the data is placed public by a person for a specific purpose, and if the usage is for that particular purpose, then it is okay to use public data. But if it is being used for some other purpose, a reconsent is required. Similarly, when we talk of legacy personal data, also we have a situation where we might have obtained a consent in the past year, but now that the new law has come, the consent format has changed, the notice format has changed, we are supposed to take a re-consent. So exemptions are can be availed even in such cases if you can invoke a sandbox provision. Okay, so these are things which have to be discussed when the DPA comes into being, but we can recognize that there are certain exemptions which are provided, which takes into account the needs of the government to maintain security of the country and of the business to continue innovation, and certain specific situations like the BPOs and journalistic entities, personal domestic purpose, small entities. So the law is drafted in order to take into account all genuine requirements. Okay, now if we look at the compliance requirement, there are two aspects which we have to look at. One is the principles of personal data processing and the rights of data subjects. Now, under GDPR, if you look at the obligations of a data controller as principles of processing, we see that there is something called lawfulness, fairness, and transparency, purpose limitation, data minimization, accuracy, storage limitation, security, and accountability. These are the principles which are mentioned under GDPR. Okay. Now, when we come to PDPA, similar things are there here also. This is where you can say there is similarity between PDPA and GDPR. But if somebody says that Indian PDPA is a copy of GDPR, it means that they have not read through PDPA, they have not understood PDPA. They are blinded by the fact that there is a current law called GDPR. They have to actually unlearn some of the concepts of GDPR before they understand the PDPA. But generally speaking, the principles are common. These are the things which are there in the OECD also in the past. These are things which are also there in the section 43A rules. That is, there should be specific, clear and lawful purpose for processing of any personal data. Then when we say specific, obviously it means that the purpose is specified, and then the question of whether some other purpose is incidental purpose or a new purpose, that is something which we need to decide. But in most of the cases, if you can justify that a particular new process is necessary as an incidental process without which the main process cannot be fulfilled, then they can be considered as incidental purpose. Okay, that's, I'm talking of purpose. Okay, there is a purpose for which the confirmation is taken or the permission is taken for collection and processing. Then I want to use it for a different purpose. That different purpose, if I can justify as something which is necessary to fulfill the original purpose, then it can be considered as incidental purposes. Otherwise, it becomes a new purpose. I cannot discover a new purpose and use the current uh, information, and that is the limitation as part of the principle. Now, fair, reasonable processing means, one, of course, it is for the given purpose. Fairness, actually, you have to look at this along with the provision that in India, the data controller is called the data fiduciary, and therefore, when we say fair, it is not necessary that that fairness should be available written in the law. It is something which can be implied out of the circumstance. It is like, say, if there is a investment manager who is managing the portfolio of a minor. Now, the minor is the beneficiary and the investment manager is like a trustee. Now, the decision to invest in a particular stock or exit from a particular stock is the decision which the trustee takes in the interest of the beneficiary, who is the minor. The minor may not be in a position to direct the trustee or the investment manager invest in this stock or that stock. So that is where, even if the minor wants to buy, let us say, XYZ stock, if the trustee feels no, that is not a good decision, he is not supposed to take that that decision which he knows to be bad just because the minor has given him the instruction. That is where the contract principle has to be overridden with the trustee principle, and the Indian law expects that trustee responsibility to be fulfilled by the data fiduciary. So the term fairness assumes a larger meaning in Indian law than in GDPR. Now, collection limitation is somewhat easier to understand because having taken a lawful purpose, having taken a specific purpose for which permission is taken, now the collection of data should be related to that specific purpose. There is only such data as is required for fulfilling the purpose has to be collected. Nothing more to be collected. That is the collection limitation. Now, the collection should be based on an informed notice. Of course, Indian law lists out certain 14 different aspects to be part of this notice. In GDPR also we have a notice. The notice has to say what type of information is being collected, what is the purpose of its collection, how long it will be retained, how it will be processed, and is it being shared with any sub processors. These are the things which has to be declared for collection. Additionally, it has to say that you as a data subject has a right to access, you have got a right to portability, right to correction, right to deletion. That is, these rights have to be told. And then we have to also tell him that you have got a mechanism to exercise these rights, like this grievance redressal system or something like that. These are the things which are there to be provided in the notice, both in GDPR as well as in PDPA. Additionally, Indian PDPA says that if the organization has something called the data trust score, DTS, then it should be perhaps mentioned in the notice that tell the data principle that I am an organization who has been assessed for DTS and my DTS latest is so and so. So this is one of the important aspects in India. Okay, so notice will be different. Then quality and accuracy has to be maintained. And this is also there in GDPR. There we use the word quality and maybe we can use the term accuracy, both are same. Then storage or retention limitation, that is, the data should be retained only for the period for which it is required as per the specific purpose. And of course, there is the accountability. Accountability includes security and fulfillment of many of these compliance aspects, like how I have tried to protect the right of the individual. So these are the principles of processing under PDPA. Though consent is a very important aspect, there are processing possibilities without consent also. Now, for example, data can be processed without consent for the functions of the state, or if there's a specific law, or in compliance of a judgment, or for medical emergencies. In GDPR, we often use the term vital interest. Here in India, we call it as medical emergencies. In the case of pandemic and disaster, and then consent may not be required in employment for non-sensitive data. This is an important aspect for companies because we have a large amount of privacy related issues related to employees. In fact, in a manufacturing company, for example, PDPA application is more regarding the employees, whereas an IT company which is actually marketing its services to the retail persons may have more exposure to personal data. Manufacturing companies may have less exposure, but still, say for example, a manufacturer of a car. Now he has got dealers, and dealers are selling cars, and anyway that personal data of who is the buyer, etc., comes back to various people, including perhaps the manufacturing company also may get it as a part of the dealer's feedback or something like that. That contains personal data. So other than that, you have got the data of the employees. So the exemption given here for processing without consent is for non-sensitive data, because at the time of onboarding, pre-recruitment verification, sometimes it will be necessary to go ahead and collect some information even to make a first offer of calling a person for interview. But subsequently, when the person has to be subjected to medical test or something like that, we come across sensitive data and for which consent has to be obtained. So in the case of recruitments, perhaps consent has to be inbuilt into the offer which is there on let us say a website, in the website, which will be sufficient because the law itself exempts collection of the name, address, etc., which are non-sensitive data, including email address, to which you can send an offer or something like that. But the more sensitive nature information, which includes the Aadhaar number, PAN number, and maybe health records, which will come later on, they become sensitive information which can be collected and processed only on the obtaining of the consent. And if that is being outsourced to a background verifying company, it will be the responsibility of the background verifying company, which will be the data fiduciary. The employer may be either a joint data fiduciary or he will only buy the services of background verification, in which case he becomes only a subsequent processor, while the background verification agency remains the data fiduciary in respect of that particular aspect. In addition to this, there are certain other reasonable purposes which are like whistleblowing, debt recovery, then credit scoring, information security, fraud prevention, search engine operation, or where there is a public interest, or there is a specific interest of the data principal for whom I have to process. If I don't process, my data principal himself will get affected. In such cases, they are all considered as other reasonable purposes. So that is why Indian PDPA has a fairly good view of what is required by the industry, and then has provided several exemptions for consent which the industry should appreciate. In fact, Indian PDPA is far more friendly to the industry than GDPR. Okay. And the Indian Act looks at data fiduciaries in different categories. One is every organization which determines the means of processing or the purpose of processing is called the data fiduciary, out of which some people, some organizations may be classified as significant data fiduciary if the data protection authority in its rules to be made considers that based on the volume of data processed, based on the sensitivity of the data processed, even based on the financial status of the data fiduciary, if they consider that this data fiduciary is processing data, and if it is not properly processed, there could be a significant harm to the data principals, then they can declare that data fiduciary or the type of data fiduciary as a significant data fiduciary. Similarly, there can be a classification called guardian data fiduciary, where the data fiduciary is processing the data of minors to a large extent. Similarly, there can be a social media intermediary also, which applies to the media entities like Twitter, Facebook, kind of a thing. Now, we'll get into brief details about this as may be required. There is also a category called consent manager. Now, these are all the different types of data fiduciaries. Now, significant data fiduciary requires to be registered. There are other requirements that a significant data fiduciary must have a DPO, must have an annual data audit by an external auditor, and so on. Guardian data fiduciary has something very specific like age verification has to be done, parental consent has to be taken. Social media intermediary has a requirement to enable that a member of the social media intermediary should be provided an option to provide his identity along with his public disclosure of a message. Like Twitter has got this blue tick. Now, blue tick is given at the discretion of Twitter, but what this law will say is that blue tick has to be given as a matter of right to the person, and social media intermediary has to make arrangements for that. And those other social media intermediaries who are not making this verifiable you can say stamp to be provided must make such provisions. Consent manager is a data fiduciary of a special kind. What is meant by consent manager is, of course, consent manager again requires registration, like significant data fiduciary. Guardian data fiduciary also may require registration. Social media intermediary is actually declared like the significant data fiduciary. Government will come up and say, and presently in the Information Technology Act, there's a definition saying that any organization which is having more than 50 lakh users, they may be considered as a significant social media intermediary. Similar definition may be used in the regulations which the DPA may come up. So all of them will need registration and a consent manager. Consent manager registration means that this consent manager can act as a representative of the data principal in dealing with a data fiduciary for the purpose of giving consent or say withdrawing consent and so on. So consent manager will be acting as a trustee of the data principles, like an intermediary in a way that, of course, data fiduciary himself is a trustee. He can collect the personal data of the data principles, but consent manager is another protective layer provided in India, so that consent manager can act as a person who collects the personal data of a group of people and then helps them in ensuring that only relevant data is handed over to the data fiduciary based on the particular purpose. So in India, where we have problems of providing appropriate information in different languages, giving a privacy policy uh, on a website where only a click of a button is taken as the permission, whereas Indian ITA 2000 doesn't recognize click wrap contracts. We need digital signatures, which are not there. Now, in such situations, the role of a consent manager becomes very important, because they can effectively take the consents from the individuals and share it with the data fiduciary as a special data fiduciary who works only on the principle of adding value to the consents. So that provision is again not there in GDPR, and maybe in USA there is another category of people called data brokers. Consent manager is not a data broker who works for money. He is a person who is a fiduciary of several data principles, but he deals with other data fiduciaries. So in between, he can add value by one, negotiating with the data fiduciary not to collect information which is beyond what is required by them, and protect the data principals who may not be capable of understanding the privacy policies in its real sense, and people like WhatsApp or even YouTube and others who are today expecting uh, expecting more than the required information to be gathered. Okay. Now, similarly, if we come to the rights of data principles, there is a right to confirmation and access, which essentially means that every data principal can ask a company, are you processing my data? If so, give me access to find out what you are processing, etc. Then right to correction. In case something is wrong, I will ask you to make corrections. But the Indian law, unlike the GDPR, says that if you are asking for a correction, and if I as a data fiduciary do not agree with what you are asking me to correct, then I will refuse. And you can always challenge my refusal by going to the adjudication authority. In the interim, I may be able to provide that this is the information I have got, this is the information you want it to be corrected, and both are presented to the persons who have access to that right. So this right of correction is conditional in the Indian context, whereas it is more or less an absolute right in GDPR. That is, if in the GDPR, it doesn't clearly say that if a person asks you to make corrections and you don't uh, have the discretion to refuse that. But India provides that option for refusal, and that extends to the request for erasure also. I may refuse to erase the data and make a reference to the adjudicator. So then there is a process under which the data subject can exercise that right. Similarly, when we talk of data portability means that personal data collected by me and something which I have built on that, like the profile, the data principal has got the right to ask it to be given back to him in a usable format. Or sometimes he may say that you please transfer it to somebody else. This right to portability is provided in India as well as in GDPR, and it includes the profile built on the data, because certain data is provided by the data principal, certain inferences we have built on that, and that inference also becomes part of the personal data. So in terms of portability, sometimes the request may be to send back even the profile. So there are instances where data fiduciary can argue that the profile incorporates my intellectual property right, so revealing it back to you and to a competitor will infringe on my IPR rights. And maybe if there is a dispute on that, it will also go back to the adjudicator, because the Indian law has made several of these rights subject to adjudication. The process of grievance redressal is an important aspect of our law, and we will be hearing a lot more of disputes being settled by the adjudicator uh, than in perhaps under the GDPR. Similarly, there is a right to be forgotten. Right to be forgotten is slightly different from right to eraser. Right to eraser is deleting the information of a particular type from the context of its usage. Right to be forgotten is deleting the information about identity of a particular person in any of the information which is in the hands of the organization wherever it is located, so that tomorrow if you ask the company, are you processing the information of so and so, you should not be able to even identify that whether your processing is data or not. That is the right to be forgotten in the real uh, sense. Now, India again adopts a very pragmatic approach to right to be forgotten and makes this right to be forgotten as subject to an approval from the adjudicator. This is again not an absolute right, and it is subject to adjudication. In fact, it is stronger than any other uh, right which needs reference to the adjudicator. Now, these um, rights can be perhaps suspended in certain special circumstances like what we are finding now, pandemic and disaster, because there is a larger societal interest there. But in any case of exercising of the rights, request has to be in writing, which may include of course electronic writing. And Indian law also specifically says data fiduciary may charge a fee as specified by the Data Protection Authority. Similarly, when a consent is to be withdrawn, Indian law provides that if the withdrawal of the consent is done for unreasonable purposes, then the organization can try to charge a fee, because sometimes withdrawal of the consent has a cost on the organization. So, right to withdraw for the consent is available, but it is subject to the legal liability if the reason for withdrawal is not considered proper. Right to forget is subject to adjudication. Right to portability includes profile information. Right to correction of data may be challenged by the data fiduciary. These are all some of the things which are different from what you may otherwise find in GDPR. Now, having understood the principles and the rights, now both these things are combined in looking at the responsibilities of accountability, which is a compliance requirement of an organization. The compliance requirements relate to privacy by design policy, transparency of processing, which is reflected in the notice, then the various audit policies, which include data protection, impact assessment, data breach audit, harm audit, annual audit, and appointment or otherwise of the DPO, grievance redressal mechanism, and of course the security safeguards. The CIA principle applies here, and rest of the things are in addition to the CIA principle. That is why we say PDP CMS, or the Personal Data Protection Compliance Management System, is bigger than ISMS or PIMS. ISMS applied to personal information is PIMS, and we are saying that the PDPA CMS incorporates not only the security safeguards required under ISMS, that is the CIA principle, It also includes the provisions of privacy, some of which are here also, which is included in the PIMS system, which is oriented towards GDPR. Plus, it has some aspects of the Indian PDPA which are not found in GDPR. So, one of the things which makes a significant difference is in the concept of privacy by design. Now, GDPR stops at saying that an organization should implement privacy by design, whereas Indian law goes a step further and says there should be a privacy by design policy. That is, every data fiduciary should prepare a privacy by design policy. They should submit it to the Data Protection Authority, get it certified by the authority, and then perhaps it has to be published on the website of the data fiduciary and that of the authority. So privacy by design under GDPR is just a declaration by the company that I have done privacy by design. And of course, when things go wrong, an auditor will find out whether privacy by design was there. Otherwise, it will be perhaps carrying a penalty. Now, Indian law says that you have to write down what is your privacy by design policy, submit a copy to me. This is more like in the case of an IPO, okay, uh, where an organization tries to, uh, you can say, uh, uh, raise public money. Similarly, now we are talking of public information, personal information, and what Indian law says is, before asking for public to contribute their personal information for your processing, please give a written assurance to them that how you will be preparing, processing their personal data in their interest as given in the um, uh, act in your capacity as a data fiduciary. So in GDPR, data protection by design and default has to take into account the risks, which is being stated like saying subject to the risks of processing. The controller shall, at the time of processing, implement appropriate technical and organizational measures. That is all the GDPR provision says. Whereas here we are going a step further to say that you have to prepare a policy. This policy will have to contain these 7 different elements. For example, the first thing is the managerial, organizational, business practices have to be codified into this policy, which includes how we anticipate data privacy risks, how we identify them, how do we avoid the harm to the data principle. So the entire privacy by design, which is expected in the GDPR, has to be put into a policy. It should contain the obligations which I am fulfilling as a data fiduciary, the technology used, the legitimate interests of businesses with which I have tried to circumvent some of the other rights, the protection I am giving for the entire life cycle of the personal data, and how transparently I am managing the system, and how I am accounting the interest of the data principle at every stage of processing. So all these things have to be part of the PBD policy. Now, when we are looking at the managerial organizational practices, we may have to actually prepare a statement which may become a data protection impact assessment or a harm audit. And then we also have to state what is our strategy for risk reduction. Then we may have to prepare a description of the systems designed to mitigate the risk. So it is a very important document, just as a company secretary of an organization prepares the prospectus of an IPO, where we state how I'm the money which I am raising from the public, how I am using it, what will happen in the next 5 years, what happened in the last 5 years, how I managed money in the past, how I am going to manage in future. Like that, this privacy by design policy will have to give an account of how I intend using personal data which you as a data principal is giving me. That is the essence of this privacy by design policy, a beautiful concept which has not been used in any other data protection law. Now, the obligations of data fiduciary, such as what is the lawful basis, what are the principles of data protection I follow, how do I take consent and notice, how I provide rights or protect the rights, these are also part of this privacy by design policy. Then, like you have in GDPR record of processing, I have to define the technology used for processing, which may include that these are the processes I use at these different points of time. So it has to have a record of the entire hardware, software, and people handling different processes, and how I perhaps distinguish non-personal data from personal data, how I use anonymization, all these things in terms of technology, including what kind of DLP system I use, what kind of encryption I use, may have to be made part of this privacy by design policy to the extent it does not interfere with my intellectual property rights. Now, in many instances, I as an organization would like to process personal data for what I can justify as my legitimate interest, which may appear to be at variance with the objective of the data principle. So I have to specifically justify the legitimate interest for processing where there is a doubt about a particular process, that if somebody can raise a doubt, I should be able to answer that. So legitimate interest for processing, legitimate interest for not getting consent in a particular aspect, legitimate interest for cross-border transfer, legitimate interest for retention, legitimate interest for denial of rights, legitimate interest for non-documentation. All these things should come under the PBD policy. Then when we talk of this life cycles, for example, if I have to fulfill this obligation, how I am protecting privacy throughout the processing of personal data, I have to chart the life cycle of personal data. The life cycle of personal data starts from the raw data, which is a combination of zeros and ones. When it is organized in a particular manner, it becomes meaningful data. But this meaningful data can be interpreted only by an individual, a human being, whether this represents a character in English, characters, alphabets, is it a name of a person or is it a name of a place? If it is a name of a person, then it becomes personal data. If it is not, it may not be personal data. So that interpretation has to be done by a human about the personal data, and then he can also think whether I can de-identify, etc. The de-identified information is also a rearrangement of the binary, but it will become non-personal data. So this whole set of identifying life cycle in terms of binary packages is part of the technology which is applied for protection of personal data. This is where a close interaction of the data protection officer with the CTOs is required, so that you fulfill the data protection requirements as suggested by the DPO through technology means. Now, when we said processing has to be done in a transparent manner, we are basically looking at the record of processing, that is the listing of different processes which we have to disclose in the privacy by design policy, and at the level of the data principles, how we are actually structuring the privacy policy. Now, if there is any gap in information between the technology departments and the DPO, which is likely to happen because the DPO is not having visibility to all your algorithms, the codes which make a particular processing happen. This is something which the DPO and the CTOs should sit together and ensure that there is a proper understanding. Now, transparency also includes the disclosure of the data trust score, and also information on cross-border transfer. Say, Indian law is very lenient on cross-border transfer, unlike GDPR. See, GDPR only provides for transfers within the European Union without restrictions. And even the UK is today looked at as an external party. Now, other than that, they have got a few countries which EU Commission feels have got adequate security practices. We don't know whether their adequacy practices assessment is good or bad or insufficient, but they have a system and they have classified about 7 countries as adequacy countries. Fine. Now, rest of the countries, they do not want the personal data to be handed over. That is, export of personal data from EU to any country which is not coming under the adequacy principles is a strict no as far as the uh, GDPR is concerned. In fact, recently the US had the taste of this idea because the uh, earlier privacy shield arrangement um, was annulled by the European court in the Schrems case. What it meant was that European court wanted the US government and the data importers to give an assurance that the personal data of European citizens, when it is being processed in the US entities, the US entities will not allow the FBI to have access to that, even if it is related to any law enforcement requirements. And they also felt that the ombudsman, which was appointed by the US government for resolving any data related disputes, because in the privacy shield there is a provision that the EU data subject should be given a remedy through the US grievance redressal system, for which the US had proposed the formation of an office called an ombudsman. Now, the EU court said that this ombudsman is going to be appointed by the US president, therefore, he is not acceptable to us. So, for these two reasons, that the ombudsman was appointed by the US government, that is the president of the USA, and that the law enforcement agencies of USA have an overriding power to ask for information about data being processed in the US, the EU court said that this privacy shield is not acceptable to us. And similarly, any other transfers are also today prohibited unless there is a guarantee that the data importer does not sign should sign a contract under what we call as this standard contractual clauses, in which the data importer gives an assurance to the data exporter of EU that I will not let my government to have any right to look at my processed data. Now, obviously, no sovereign government will allow a situation where if data is being processed in India, and if I, as a law enforcement agency, want to look into that data for solving, let us say, a crime or something like that, if you say, no, this is data which I have got under the GDPR contract, I will not let the government look into it, that will not be acceptable to any country which is having some kind of a self-respect. Therefore, India also will not be able to give such kind of an assurances. Therefore, this EU principle of building adequacy based on such kind of irrational demands on other countries is not going to work. However, it is possible for the EU data exporters to take a explicit consent from the data subjects and then get a permission to transfer the data to, say, Indian data processing agency or so on. So Indian data importers who work as processors should check what kind of SCC, that standard contract clauses, they are forced to sign from a data exporter. If they have signed contracts like what I was telling, that I will, a data importer takes the responsibility for ensuring that the data will not be accessed by the law enforcement agencies, or that I will give a right of remedy to the data principal with whom I may not even have any kind of relationship. Those are irrational demands which might be there in my data processing contract, which I might not have observed. So those are the things which the data processors in India will have to take into account. So otherwise, the Indian PDPB is much more liberal because it says that personal data, that is non-personal, non-sensitive personal data, can be freely sent out of the country for processing. Sensitive data can also be sent out of processing, provided one copy of the data, sensitive personal data sent outside India, is also held in India, and you have an explicit consent from the data principle. That is, you take a consent, keep a copy, and then send it for processing. Of course, RBI, in terms of payment related information, has stated that you can get it processed outside, but you have to bring it back to India. That is a sectoral additional regulation. But otherwise, the Indian cross-border restrictions apply only to sensitive personal data, that too only for a copy to be held. Sensitive personal data today includes financial information, health related information, sex orientation kind of a thing, then the official identifiers like the Aadhaar and PAN, and of course biometrics. These are the things which are considered as sensitive personal information. There is a possibility that government may declare a set of personal data as critical information, and if they define anything as critical information, that will be prohibited from being sent out of India. So this was what was proposed in the PDPB 2019. So JPC has been looking at this. There is a possibility that JPC may bring back a system where even the personal data which is sent outside India, a copy has to be held in India, or the JPC may make some suggestions on the critical personal data and extend the definition of critical personal data to something like the biometrics or the Aadhaar kind of data, in which case they cannot be exported. So we have to wait and see what will happen when the final bill comes. Other than that, the information on cross-border data, if it is being done, should be part of the transparency measure, which is given out in the form of a notice. So transparency requires the information being made available to the data principal. There are, of course, 14 points in the notice and informed consent, which includes DTS, which is one of the most important aspects which we have to remember. Then in the whole accountability criteria, the interest of the data principal should be accounted at every stage of processing. Now with this, if we quickly go through what it means to being a data protection officer in India, the first thing we must remember is that every significant data fiduciary needs to have a data protection officer, and he should possess such qualifications and experience as going to be specified. As of today, we have to interpret what are the qualifications. Or qualification doesn't may exist in college degrees. It is only the certification agencies like FDPPI which has created the qualification, if at all there is a qualification. Otherwise, we have to go by the experience and interpretation of what are the responsibilities of the data protection officer, and then from there we have to find out what kind of credentials a data protection officer should possess. One thing is the data protection officer should be based in India, and will be the representative of the data fiduciary with reference to the dealings with the regulatory authority. It says that he may be assigned any other functions within the organization, but conflict situation may arise. So if there is sufficient volume of personal data processing in an organization, it may be necessary to have a data protection officer as an exclusive officer. Since it is mandatory only for a significant data fiduciary, all significant data fiduciaries will have substantial work, and therefore a data protection officer will become an independent person, not necessarily a person who also does this, also does the other things. But exactly whether an external consultant will be available or not, we have to wait for more the regulation to come out. But as I interpret, there will be an internal employee who will be designated as a data protection officer. The organizations can use external consultants to support the internal data protection officer. The responsibility of the data protection officer will include monitoring of the data processing activities of the organization, maintaining records of compliance. Now, this monitoring will include providing information and advice to the company, provide advice on data protection impact assessments, which are audit reports which have to be prepared whenever a new technology is to be adopted by the company where there is a significant risk. This DPIA may have to be approved by the data protection officer, and in certain cases it has to be filed with the data protection authority. We will look at the final regulation to find out whether it will be submitted at periodical intervals or it has to be submitted as and when it is required. Then this DPO will be the person who will provide advice on the PBD policy, personal, that is privacy by design policy, to be prepared by the DPO. Apart from these internal activities, the DPO will provide assistance and cooperation to DPA. When we use the word assistance and cooperation, you will imagine that DPA has got a certain responsibilities which is holding the organization responsible for non-compliance. So DPO is expected to ensure that the DPA's role to find fault with the company is not frustrated. So he cannot take a stand that I am paid salary by my company, so I will not tell you how we are deficient. So he has to manage the conflict with the larger interest of the public in mind, and that is one of the significant changes to the type of work which DPOs will have to manage. He will be the point of contact for data principles. So managing this requires skills which are legal in nature, that is, must be aware of the PDPA, must be aware of other Indian laws such as ITA 2000, must also be aware of international regulations like GDPR and other country laws. So these are the legal knowledge which is required. He also requires skills of audit, because one, he has to conduct some of the internal audits himself, like the DPIA or data breach audit or harm audit. He has to also undertake periodical compliance audit. He has to make an audit of the business associates. He has to audit contracts which talk about data protection. Additionally, he has to support or handle external audits which are mandatory once in a year for significant data fiduciaries. This external audit has to be done by data auditors, who obviously has to have all these skills which I already stated. This is not similar to the financial audit, and you cannot expect your chartered accountant firm to do this. This is a separate skill which is required. So data auditors are going to be developed separately, and the Data Protection Authority will accredit those data protection auditors, and organizations like FDPP are creating the knowledge and skills and certifications to enable people to apply at the appropriate time to the Data Protection Authority. And Data Protection Authority may come out with its own criteria for accreditation. So those data auditors are going to be the persons who will be authorized to submit annual data audit reports, which becomes part of the submissions to be made to DPA. These annual data protection audits will also assess the data trust score. The DPOs needs to have a lot of technical skills, because he has to interact with technical teams. He has to prepare the DPIA or defend it with the DPA. That is, he has to take the DPIA prepared by the technology department, go to the DPA authority, and then say this is what we are doing and we are not infringing on any privacy rights, etc. He has to design appropriate incident management policies, because the incident management policy to be used for privacy related issues is different from what may be used for existing policies, which may be used for under ISO standards or BS standards or any other standard, because this incident recognition will be based on the applicable law, and the DPO has to have enough technical knowledge to understand the technology environment of his organization, how to challenge, confront, and convince tech teams to change processes, even if the teams talk of artificial intelligence, IoT, big data, and big say terminologies which people don't understand. So a pure law person will find it very difficult unless he knows a lot of technical uh, things. He should be even able to evaluate technical tools for personal data discovery, consent management, data leak prevention, encryption, access control, and so on. So DPO skills include technical, but it will not end with only technical. It will have legal skills. It will also have managerial skills. He has to motivate and lead an internal team. He has to create acceptance of the privacy culture across the organization. He should be able to negotiate internally and with a regulatory authority like DPA. He should be able to handle grievance redressal, which may include mediation, arbitration, and negotiation skills. And he should be able to manage adjudication hearings, and of course, at the appellate tribunal, he may perhaps take the legal assistance, but adjudications, probably he will be the main leader of the team which will represent the organization. He will have to convince influential customers to fall in line with Indian laws, because many of the customers are more powerful than us, and sometimes their non-compliance can hurt us. So the DPO has to manage conflicts which are definitely going to arise. Conflicts can be between individuals and the organizations, which is the data protection principle, principle, data principle, raising his rights, issues, etc. Sometimes he has to snoop to conquer, sometimes he has to duck and avoid to survive another day. Sometimes he has to be aggressive and he may have to take risks. Sometimes perhaps should be submissive and gulp insults. That is why we say that it is an understatement to say that skills are required to be a successful DPO. In fact, what is required is much more than what most of us possess, but we have to gear towards this all-round skills. Every one of us have to try to become an all-rounder like Gary Sobers. That is the only way a DPO can become useful to the organization. Now, very briefly, if you look at the audits, there are different kinds of audits which are recommended under our law, which is data protection impact assessment, which is done whenever new technology is being used, data breach notification whenever data breach happens, harm audits whenever there is a clash of interest between two particular data principles, then compliance audit, which happens once in a year or so. Specifically, what is required is mentioned under a particular section, and based on that, annual data audit by an independent data auditor is required. It is here that we see that the market is not ready in most of the time, because most of the time we are trying to do or prepare based on existing audit frameworks, like ISO 27701 or something like that, which is like fitting a square peg in a round hole. So what we feel is that either 27701 or 17428, which was recently announced, are insufficient to meet the requirements of the PDPA compliance, and we have to go for something new called PDPSI, or the Personal Data Protection Standard of India, which is a unified framework which can be applied for PDPA India with specific controls extending to DTS. It can also be applied to GDPR or any other applicable law, while a common set of controls apply to all the requirements. So this is a unique framework, not specific to any particular law. It can be used by an organization for self-implementation. It can be used by a consultant to guide an organization. It can be used by an auditor for certification and DTS assessment. The whole process of PDPSI is built on 12 standards and 50 implementation specifications, and it can be implemented with the assistance of a consultant. It can be evaluated by an accredited auditor, and a certificate of compliance along with a DTS evaluation can be provided by properly accredited auditors who use this PDPSI process. This DTS itself is a new concept which is not known to many auditors. Actually, the DTS score, which is used by the FDPPI system, which is also now adopted by the DNV, is that it looks at the compliance under 5 different responsibility centers: management, DPO, legal, HR, and technology, and arrives at a DTS score, and which can be perhaps disclosed. So just to summarize, personal data protection is different and more complicated than information security. Risks in non-compliance can be hugely damaging. DPO is accountable for compliance both for the organization and to the regulator. And Indian PDPA is different from GDPR. Compliance is different, applicability is different, and the DPO role requires techno-legal knowledge, conflict resolution skills, leadership skills, etc. Therefore, it will be a CXO position in most organizations. It could be a role higher than that of the CISO, and therefore we should be prepared to take up this role if it is available. Thank you, friends. For more details, you can contact me in either my email or through my websites.